Abhyuday, can you please tell us about the new upcoming areas and trends in the field of cyber law, fintech, and technology contracts?
Okay. There are many new emerging areas in the area of cyber laws, fintech. Okay. So we need to look at it from two perspectives. One is that how business is evolving and how that creates new kinds of legal work. And the second way we need to look at it is that what kinds of lawyers can perform that legal work. So how is business evolving and what is the kind of legal work that is arising? Let's look at that first. So you have a lot of Indian companies, for example, which are becoming large global players, okay, which means that they will be capturing their customer records and data will be very, very huge. And data is what has become important in the new economy. Different ways to use, collect, analyze, process data and offer new kinds of discounts and offers to customers. Now, when an Indian company is collecting data of global customers, then global laws on privacy and data protection apply. If you are operating in the European Union, you have presence there, you're serving customers there, then you will need to comply with GDPR. And there are similar legislations in, say, Hong Kong, Singapore, and other countries, okay, including in India. There is a personal data protection bill which has not been passed yet, but there is already India's sensitive personal data information rules which exist under the IT Act. So you need to ensure that in different countries your operations are actually complying with this. Now, this is not a pure play compliance issue. A lot of times when you do collaborations with other brands on how we want to process and share data, each such collaboration, each such contract gets hit, and you will need to ensure not just that there is compliance as a routine in a routine way, okay, but your compliance should add up to the business objective. So your contract with a partner with a collaborator basically, with a third party, cannot be violative of what the GDPR says and the manner in which you've collected consent. If you want to use your customer data in a different way, give it to somebody else to promote and to cross-sell offers, then you will need to collect data like that and get consent in that way. So you will need to either amend your policy or read down that contract, okay, so that everything is consistent. Now, this is one kind of work. Then there is a whole area of work around technology contracts. So technology contracts could mean a variety of things. One could be software development related agreements, where a company is engaging developers to create a solution. Now, software development agreements require a lot of interesting and unique clauses. The most important ones are, milestone-based payments. That's very difficult sometimes to write down. Then how to test the functionality of the software, how to create documentation of a software. Now, every technical software, it works on your screen, but behind that is a code. How that code runs also needs to be documented in a kind of plain language, okay? And that documentation should be able to be read by a third party. Otherwise, if your developer falters and you terminate the contract, you're not going to get back the payments that you made earlier till that stage. So if you terminate the contract midway, you need to be able to replace that developer with somebody else, for which you need documentation. You need somebody to verify that the documentation is correct and usable, and before the contract is terminated, because otherwise you will be the one at risk, right? So software development agreements have these kind of new aspects that are there. Also, something that is unique to software development agreements is that the number of features, iterations, milestones keep changing frequently. There are many revisions and timelines. So how the contract allows for these modifications to happen on an ongoing basis is very important. There needs to be a robust mechanism where both parties can keep agreeing to fluctuations and keep the relationship going on smoothly. Otherwise, that relationship will break, not because the parties are interested in breaking it, but because your contract is not defining the relationship and the duties of each party clearly enough. So the ambiguity, which is basically the lawyer's job to resolve, that ambiguity will become the source of failure in the relationship. So you don't want to do that. The other thing is that a lot of times there are technology related service contracts which are there. So these are in the nature of master service agreements and statements of work. So the service order is actually issued in a statement of work. Again, this can be for different kinds of services. You can extend statements of work to non-technology related services also. But in a technology related service, let's stick to that for now, you will need to again define the scope of work in a lot of detail. Now this is where the business teams and the lawyers sit down together and write down what the scope of work will be, because for every different kind of technology service, the measurements and deliverables are different. The key performance indicators that the service should meet, that is different. And what happens if there is a shortfall in the service or there's a delay, that is different. You will not, because these are long-term relationships, you will not use every slight evidence of a delay or a shortfall to terminate the contract. Okay, you might just claim a price adjustment. Okay, now what is this adjustment going to be like? This is what the lawyers and the business teams from both sides need to figure out. A lot of times you have in-house counsels doing this with the business teams. So this is about a statement of work. Now, one thing that frequently happens, as I said, in software, the requirements keep changing a lot because you realize that the market needs something a little different from what you originally envisioned when the development work began. So when you do that, how does that impact your contract? You will create something called a change order. Okay, a change order is a modification in the statement of work, and it communicates how the original provisions stand adapted in light of the change you are requesting. Learning how to do this will enable you to perform this kind of job for a company as an in-house counsel, or a smaller company which cannot afford to hire a permanent in-house counsel and afford the rates of an in-house counsel. That will give you this work as a freelance lawyer or an independent lawyer. They can give you this work from time to time as and when it arises. Once you build your relationship with the company, having done 1 or 2 such contracts, they are likely to contact you more for any variations or for more instances of such contracts. They may even recommend you. Okay, now the next part is that there are standard clauses in technology related contracts which are heavily negotiated, and especially by lawyers. These are provisions around indemnity, limitation of liability. Okay, so basically what happens when a software provider is providing a kind of app or a software to a business which is using it to run his or her operations. Now what I charge for the software is completely unrelated to what revenues the business generates. Yet because they are using my software, they are paying the price for it, they will want to say that any disruption in my software will obviously disrupt their service that they are providing, and they will want to link the damages they suffer, basically the lost economic profit which they would have had if they ran their business, they would want to put it on me. Now I am not their business partner, I am only providing a software. So as a software provider, now depends who the lawyer is acting for, but if I am creating software, I want to minimize my liability at most to the level of consideration I'm going to get, right? I'm not going to have an uncapped exposure business wise to the risk the other party is facing. So if my software was down for 2 days and their 2 days profit margins run into a few lakhs, but my software is maybe 50,000 a month, I'm going to have a small price adjustment, right? So that's how I'm going to cap the indemnity that arises, the limitation of liability also. So my indemnity will be limited to direct losses that are suffered because of me, and then there will be a limitation of liability that in no case shall my liability extend this amount. And if I'm negotiating for the other side, then they will negotiate with me for exceptions to this, and they will want areas where they want unlimited liability so that I compensate them for any kind of loss they suffer. Now this is an example of a situation where these kind of technology contracts are negotiated. So we just covered, let's just wrap up what we covered. We covered the area of data privacy and GDPR. Note over there that Indian lawyers may well be required to be fully conversant with foreign laws, and this is unique about this aspect. About this area of law in fintech and cyber laws. Now the next part is we covered about technology related contracts and technology services related contracts and their negotiation. Now there can be a whole lot of other work. Now, for example, RBI has entire systems for regulating fintech related companies. There's P2P lending. There's Paytm, Airtel Payments Bank. So there are payments banks. There's a whole lot of stuff that there are other financial innovations which are regulated by RBI. At the same time, if you are a litigator, you might want to consider trying out or specializing in claims for fraud, because RBI has a separate ombudsman related scheme which can be used in case of cyber fraud. Now this is a separate thing from what you would do under Consumer Protection Act, which is also something that a cyber lawyer should look at, that how in case of internet fraud can I use the Consumer Protection Act to get relief for my client. In this way, the boundaries between cyber law and other areas sometimes merge also. So you will look at the RBI schemes, you can look at the consumer protection law, you can look at filing cyber complaints, regular cyber complaints. In some cases, many of the remedies that are there are unconventional. For example, in case of cyber stalking or in case of content that is defamatory, you might not always take up conventional remedies. You might want to take up, let's say, approaching an offshore intermediary and sending a takedown notice. Okay, now that is highly effective because for a client, what do they want? They want any content against them, infringing their trademarks, infringing their IP or defamatory to be removed first. So you can identify a platform like YouTube or Facebook which is operating offshore, issue them a takedown notice under foreign law and have them take this down, and that can make you highly productive and highly effective for a client. In some cases, you might want to file a civil suit or criminal defamation case when you want to leverage the idea of imposing a threat on the other side, or when you want to increase the other side's costs by theirs having to present themselves in a court of your choice. So they will have to come there to defend themselves. Okay. Now these are strategic considerations. Somebody who can learn these can serve clients effectively. Another side is around cyber squatting and online infringement of trademarks. So what we were talking earlier was primarily around takedowns for copyright, but you can have a lot of this for trademarks. And so for example, somebody takes up, like this happened for a lot of celebrities, well-known brands, that people started competing websites, okay, in the name of a well-known brand. And now these websites had to be taken down immediately. What do you do? And you don't know also who the squatter is a lot of times. Who owns this domain? He has registered this with a domain name registry under a false name maybe. You never know. Okay. So now how do you get that website taken out? In that case, you might want to use a UDRP process which the WIPO maintains. This is for .com and similar top level domains. If it's a country level domain, then you will use a .in dispute resolution process. So at the time somebody purchases a domain name, you sign an agreement with the registry which has a resolution clause through arbitration for these domain name disputes. If you invoke this machinery, basically the registry has the power to retransfer the domain to the bona fide owner. So if you can use this process well, you can be helpful for your brands. If you want your client to get commercial relief and not just transfer, then you will want to use a civil suit or a trademark infringement remedy. Okay. Now this depends what you want, what is the outcome the client wants. As a lawyer, what do you need to know? One is that if you are an in-house counsel, then you need to know how to implement the solution that the company wants. If you are a litigator, you need to be comfortable with all these strategies and the different kinds of reliefs that they provide to customers, and you need to be able to use them. So right now what I said is which strategy you can use when, but you don't know how to implement this. So if somebody gives you a mandate, okay, go ahead and implement this, or this is a problem I'm facing, what should I do? You can tell them, okay, you should do this, but then it will be your job to implement it. So getting this done is what we teach in the Cyber Law and FinTech Diploma course. Okay, I hope this was helpful for you. Feel free to ask any questions or share your feedback by commenting, and cheers, and look forward to hearing from you.